Chapter 26. Commencement of an action at common law. Sec. 135. The original writ. Each court had its characteristic process. That of the common pleas was the original writ, which was the beginning or foundation of the action at common law. Aggrieved parties were required to make application or suit to the Crown, the formation of all justice, for that particular remedy which he is determined or advised to pursue. Parties had to sue out, or purchase by paying the stated fees, an original writ from the Court of Chancery, which was the shop or mint of justice wherein all the king's writs are framed. The writ was the symbol and expression of the king's authority and power. It expressed the king's sole right over the dispensation of justice, a right which the king exercised on his own terms until Magna Carta was extorted from King John. Original writs were necessarily used centuries before the establishment of the Court of Chancery and were issued by the clerks of that court after it was established. The original writ was a mandatory letter from the king, issued in parchment, sealed with his great seal, and directed to the sheriff of the county wherein the injury was committed or supposed to have been committed, requiring him to command the wrongdoer, or party accused, either to do justice to the complainant, or else to appear in court, and answer the accusation against him. The day on which the defendant was ordered to appear in court, and on which the sheriff was to bring in the writ and report how he obeyed it, was called the return of the writ. It is said that original writs never obtained in any of the United States, and that they should not be compared or identified with our modern summons, on with other original process to bring the defendant into court. Sec. 135a. The process. The next step in carrying on the suit after suing out the original writ, was called the process, which was the means of compelling the defendant to appear in court. This was sometimes called original process, being founded on the original writ. There was also mezzanine or intermediate process, which issued, pending suit. Mezzanine process in Ohio, under the common law procedure, was either by a summons, or by a capias ad respondendum, and was sued out of the clerk's office, and not out of the Court of Chancery. As in England, no original writ preceded the summons or capias. The summons was a mandatory letter, purporting to be issued by the state, commanding the sheriff to summon the defendant to appear in court on a given day and answer the charge against him. A capias ad respondendum issued in like manner, commanding the sheriff to take the body of the defendant, and have him before the court, to answer the charge of the plaintiff. The first step in the commencement of a suit was to file a precipe with the clerk, which was much the same as the precipe under the present procedure, except that the kind of action, that is, the nature and form of the action, the substance of the cause of action, had to be briefly set out in the precipe and endorsed on the writ. If a capias ad respondendum, attachment, or writ of replevin was issued, an affidavit had to be filed. The declaration had to correspond with the precipe. If the summons was properly returned, the defendant was thereby considered in court and could be declared against accordingly. The plaintiff could not file his declaration in any instance, or under any circumstances, until the writ was actually returned to the clerk's office. This feature of the common law practice in Ohio was similar to the commencement of an action in England by means of the original writ. After appearance, the plaintiff must file his declaration within the time limited by the rules of court or be non-suited. Sec. 135b. The change by the Code. The Code Commissioners said with reference to the commencement of an action, "Hereafter there will be but one mode of commencing all civil actions, by petition and summons." This is very similar to the present mode of commencing a suit in Chancery, by bill and subpoena. Heretofore there have been various ways of bringing suits, as by capias, by replevin, by attachment, by summons, and by bill and subpoena. The one mode of petition and summons, we have provided as a substitute for all others. The body may be taken, goods may be replevined or attached, but whether any of these steps be taken or not, the suit will be begun in the same way. Capias, replevin, and attachment, instead of being continued as writs, to be used only at the commencement of a suit, are changed into provisional remedies to be used during the progress of the suit. The form of the summons is an improvement on the old subpoena and summons. The manner of service in ordinary cases is the same as before, and the manner of service on corporations, domestic and foreign, is taken from existing statutes. such changes only being made as seemed to be proper. The cases in which service can be made by publication, are increased in number. It seems to us, the change in this respect, will be approved. It will be observed, we have dropped service by proclamation, Swan, 650, seconds 18, and allowed service by publication in the same cases. This title contains very much of our present law relating to the manner of commencing actions and serving process. Section 77 provides when the action may proceed, where all the defendants have not been served. By the existing practice at law, when there are several defendants, and any of them have been served, but not all of them, the action may proceed against those served. By the existing practice in Chancery, all the defendants must be served, before it can proceed. If we are to have but one system of practice, we must have but one rule for such cases. This section is intended to take the place of the two old rules. A future section, under the head of judgment, provides a method of making defendants jointly indebted on contract and not served, parties to the judgment that may be rendered against those served.